Hey, Reed, you spotlighted you if you want to welcome everyone and then shift back to me.
Okay, so we'll start then. Well, good evening, everyone. Reed Alley, Chairman of Freedom Defense Canada. And I want to welcome you on behalf of the Board of Directors and the membership of Freedom Defense Canada to this very important Zoom meeting tonight. As you probably are aware, Freedom Defense Canada has been in existence for about 6.5 years. And our main objective is to be able to communicate with people who feel they are conservative or social conservative and are feeling somewhat marginalized by what has been happening in our country. Because of that, we felt it was important to reach out to people of like mind. And we have put together a website, we put together a newsletter, and when we were able to meet face to face, we held quite a number of in-person meetings up and down Vancouver Island. We haven't ventured over in the mainland. We felt that our duty was to the people that are around us first. We do have members who are in other parts of Canada, but we are now, of course, involved in communicating with people on social issues, things that are important to us, that are happening in our country. And the only way we can do that now is through Zoom meetings. So let's see. Perry, you have told people that this event will be recorded?
Yes, in fact, we're recording it right now.
Okay.
And later we'll splice it later on. So this is being recorded and it will be featured on our FDC website. So if people want to go back and listen to it, they can do so. Okay.
Well, it's our great pleasure this evening to have with us
hold on a
the
minute.
Honorable.
I'm sorry,
Reed. If I missed something?
Yes, you did, actually. I'm just going to explain the Zoom etiquette, then it'll be time to introduce Brian. So that's on the list. So can I introduce myself here, folks? My name is Perry Foster, and I'm the Communications Director for Freedom Defense Canada. I'll be managing the event tonight. So in order to create an atmosphere of respect, we ask that you mute your mics. And then especially for Brian's presentation, which should take, I hope, about 30 to 40 minutes, or I think it will. After that, we'll have a question and answer session. And I'll tell you the details of that when Brian's presentation is finished. Okay, so that's something just wanted to go back over. And
all right,
you want to shift.
Thank you, Perry.
Yeah.
So it's my pleasure to introduce to you the Honorable Brian Peckford. Brian is probably no stranger to you if you've been following Canadian politics for as long as I have. Brian was the third Premier of Newfoundland and Labrador. He was first elected to the legislature there in, I believe, 1972. Is that correct, Brian?
Yes.
And for a number of years, he held portfolios in the progressive conservative governments that were in charge in Newfoundland. He served in a very important portfolio. I think all of us will recognize the importance of it. He was the Newfoundland Minister of Mines and Energy. And in those days, he certainly had his hands full negotiating with the provincial government or the federal government and others to make sure that Newfoundland had a huge role to play in the energy industry across Canada. Now, you served for, I think, how many years did you serve in the as Premier?
I served 10 years.
10 years, that's right. That's a long, good stretch. And he of course is retired, but we old politicians never fully retire. We just get retreaded. So Brian has been quite active over the last number of years. I first got to know him when together we were active in reviving the BC Conservative Party. There's another revival of that party going on now. And Brian, of course, got quite involved in what our federal government particularly did to all of us as Canadians during the pandemic. And as the last surviving signatory of the repatriation of the Canadian Constitution, he has quite an interest in what the government's been doing in view of how they've managed the pandemic and trying to make things look like they're okay by referring to the Constitution, particularly the convoy, the truckers' convoy, and all of the things that we saw on TV and in the news about how our government, instead of talking with them, simply tried to break up whatever they were doing by passing all kinds of things, particularly the measurements, the emergency measures things. So in light of that, Brian has taken it upon himself and others, working with the Justice Center and others, to take the federal government to court over the way they interpreted the Constitution and used it against Canadians just this year. So Brian, we're just thrilled to have you with us. We look forward to what you have to say to us. You're going to, I know, give us a lot of information and sort of what's happening today. So welcome, glad to have you here.
Thank you very much. It's my pleasure to be here, and I hope most of the people who are going to be on this Zoom call have now arrived and are available to listen to this event. And I say that because it's important to be here for the beginning of it, because I want to give all of you a context of the situation and a historical context, so you put it all in perspective and have a better understanding and appreciation of why people like me have come forward to oppose what the provincial and federal governments have been doing relative to our Constitution, especially as it relates to individual rights and freedoms of Canadians. Canadians from coast to coast to coast have had their rights and freedoms violated by the governments. Okay, so let me begin at the beginning, and I'll try to be as short as I can to give you time for questions. But this will take a little bit of time, hopefully 25, 30 minutes or less, but we'll see how I get on as I go through this. Okay, everybody here on this call and most Canadians realize, of course, that Canada was formed in 1867 by the enactment of our first constitutional written document, which was the BNA Act. And that was in 1867. The BNA Act, of course, stands for the British North America Act, because at the time, in 1867, the northern part of Canada was still called the British North America. The United States, the other areas to our south that had been British, rebelled and revolted and created their own country in 1776. But we didn't go that route in northern part of North America. We stayed with the Crown and with the United Kingdom, and then through a series of events just before 1867, it was decided through Lord Durham and others earlier on to try to create a country on the northern part of North America, and that led to the British North America Act of 1867. That act created Canada as we come to know it today in the sense of its wording. It started off as a very small country in terms of how it later developed. There were only 4 provinces that created Canada in 1867 under the British North America Act. That was Upper Canada, which became Ontario, Lower Canada, which became Quebec, and then it was New Brunswick and Nova Scotia. So these were the 4 provinces identified in the British North America Act, only 4. The other 6 came later. And then, of course, the 3 territories as well of Northwest Territories, the Yukon and Nunavut, only lately in the last few decades. And so now, today, we have a federal government, 10 provinces and 3 territories, but it never started like that. The BNA Act defined that Canada would be a federal nation. We would not be a unitary state like France or the UK. We would be a federal state like Germany or Australia or the United States. In other words, the various units of the country would have some powers, like the provinces, like the states of Australia or the states of the United States. So the power was shared from the federal government to the provincial governments. And this becomes very important as the country develops. All the power was not in Ottawa. Some of the power was in the provinces. And that's why the provinces are so important, because under the BNA Act, they have complete jurisdiction over health and education and a lot of the natural resources of the country, non-renewable and renewable resources of the country. So that means, and they have the power of taxation as well. And so that's how the country started. And in that BNA Act, it defined what the powers of the provinces were and defined what the powers of the federal government would be. But one thing was missing in the BNA Act, by design really, and that was there was no written individual rights and freedoms protected in that BNA Act. It was silent on individual rights and freedoms because we were being created out of the United Kingdom, if you will, in London. And of course, the British people depended upon an unwritten common law, which really got started back in 1215 with the Magna Carta. And so they had a different history of individual rights and freedoms. And so that kind of history got passed over to us in the BNA Act, where it was absent, silent about written individual rights and freedoms. And so that's how we got started as a country. We did not have a Bill of Rights or a Charter of Rights like the United States of America. The United States of America, as I said earlier, was created in 1776. And only in 1791, only 15 years later, they had a Bill of Rights in their Constitution. So they had a written Bill of Rights almost from the start of their country. Only 15 years after they were formed, they had a Bill of Rights in their Constitution. And here in Canada, we did not. And we did not get a Bill of Rights or Charter of Rights until 1982. And so all the while, the rest of the 19th century and into the 20th century, Canadians had to rely upon unwritten British common law and customs and precedents for defense of their individual rights and freedoms. In other words, if you went to a lawyer before the Charter of Rights and Freedoms, then that lawyer would look to the British common law and look for precedents and examples there of court decisions which were about individual rights and freedoms, and use those to defend his clients in court. That's the way the system worked. Now, importantly, all through the, as I say, 1867 to 1900, then all the way through the 1900s until 1960, the first measure was taken to put some of our individual rights and freedoms in writing. And that was done by somebody who a lot of you people, if you're as old as me, I'll turn 80 this year, was John Diefenbaker. John Diefenbaker was a prairie lawyer from Saskatchewan and became Prime Minister of Canada. And in 1960, he introduced a Bill of Rights into the House of Commons. And that was the first time ever in Canadian history that individual rights and freedoms were recognized in a document, a government document in Canada. So John Diefenbaker and his government is to be complimented for beginning the process of putting our rights and freedoms in writing, okay? However, it was not complete. The Bill of Rights of 1960 was not complete, and that's why we ended up getting the Constitution Act of 1982. And why was it complete? For two reasons. One, it was a federal act, In other words, it could be changed quite easily by successive governments, because all they would have to do was go to the Parliament and propose an amendment or propose even its elimination. And secondly, being a federal act, it only applied to federal jurisdiction. In other words, it did not apply to all Canadians. It only applied to Canadians who came under federal jurisdiction. And being a federal nation, then it didn't cover people who were under provincial jurisdiction. And so those were the two reasons why this was not complete, but it was a beginning and it was a start, and it was a very important start by Mr. Diefenbaker and his government of the time. Of course, a lot of liberals and progressives and NDPers and the like don't like for me or anybody else to talk about a conservative prime minister who actually began the course of our freedoms through putting the Bill of Rights in federal legislation. They don't like to think that. They like to think that they are the people who are in favor of freedoms and rights and so on. But no, it was a conservative government that actually began the ball rolling towards a written Charter of Rights and Freedoms. And so between 1960 and 1980, there were talks from time to time among the first ministers and among other scholars in Canada about trying to do something to complete what John Diefenbaker started. In other words, have a Charter of Rights and Freedoms or a Bill of Rights, but have it in a constitution, because that will protect it more than if it's in federal legislation. And that when you put it in the constitution, it will cover all Canadians, because that will be a national document, not a federal document, not a provincial document. And so talks did proceed off and on from 1960 to 1980, but the time didn't seem to be ripe and nothing came of those talks. One of the biggest stumbling blocks of those talks, some of you might remember, was an amending formula. Because at the same time as we were going to do a Charter of Rights and Freedoms, we were going to patriate the Constitution. In other words, bring it back from London and therefore in the future, all of new amendments to our Constitution will be done in Canada. In other words, patriation would complete our sovereignty. We would be completely sovereign and not have to refer back to London anymore for anything to do with Canada and its Constitution and how it proceeds. Canada could do it on its own with its own amending formula. Well, that amending formula became a stumbling block between 1960 and 1980. So, but around 1980, quite a few of the first ministers and others believed the time was right to see if we could patriate the Constitution, bring it home from London, and also attach to it a Charter of Rights and Freedoms. Of course, once you open a Constitution and do something major like that, that wasn't the only things that were being considered. So contrary to what many people have been saying in Canada over the last 2 years, wrongly, is that we weren't just negotiating a Charter of Rights and Freedoms. We were negotiating a Charter of Rights and Freedoms, patriation, and other matters. So, and those other matters included Aboriginal rights, included equalization, included amending formula, included minority language rights. So what came out of that 1981 negotiation that I was a part of as First Minister was the Constitution Act 1982, as we know it today. So it wasn't just a charter, it wasn't just amending formula. There were a lot of issues at play and negotiated. So the Charter of Rights and Freedoms was not negotiated on its own, but had to find its place and being negotiated with other things that I just mentioned. And so we began negotiating in 1980 to patriate the Constitution, have a Charter of Rights and Freedoms, and the other issues that I mentioned. And it seemed like we were going to make some progress on that. But unfortunately, that progress got halted when the Prime Minister of Canada at the time, Pierre Elliott Trudeau, decided that we were too difficult to deal with. He was going to leave the table and do it on his own. And so he, most of you will remember, left the table and decided that he had the power, he had the constitutional power, he had the legality to patriate the Constitution and attach a Charter of Rights and Freedoms all on his own. The federal government could do this, he thought. And so he passed a motion in the House of Commons in Ottawa, and it got approved by the Parliament, by the House of Commons and the Senate, to patriate the Constitution and attach his version of the Charter of Rights and Freedoms. Well, what happened as a result of that is that 8 of the provinces believed that the Prime Minister did not have the power to do this. And so the provinces split, the 10 provinces. 8 opposed what the Prime Minister was doing, and 2 stayed with the Prime Minister. The 2 who stayed with the Prime Minister were Ontario and New Brunswick. The other 8 provinces opposed it. So it started off 6 or 7, but it ended up being 8 opposed what the Prime Minister was doing, and took him to court, took his government to court, and said, what the Prime Minister is doing is unconstitutional. And so we took him to court in the Appeal Court of Newfoundland, in the Appeal Court of Quebec, and the Appeal Court of Manitoba. We didn't go to all 8 provinces. That was not necessary. We thought if we picked 3 courts of appeal and appeal it there, that would be sufficient to make a statement and to be appealed to the Supreme Court of Canada, of course, because we knew that the federal government would do that if these decisions came down against them. Well, once we did that and started the ball rolling there, the Prime Minister, Pierre Elliott Trudeau, Justin Trudeau's father, we've had to put up with the Trudeau family for far too long in our history, and it's been devastating to our democracy and to our economy as well. Sadly, many Canadians are only now beginning to see that the Trudeau legacy in history will not be a kind one. It will be a very unkind one, but it's taken some Canadians a lot longer to wake up than many of us who are listening to this program tonight. In any case, we took him to court, and he then himself and his government got a little cold feet in the sense that they started to realize, I think, that they weren't on as safe a ground as they thought. And so he used the power that he had, and all first ministers have. He was going to refer to the Supreme Court, his highest court, to see if it was constitutional. So what really happened was all 3 of the decisions of those appeal courts came to the Supreme Court of Canada, along with the reference from the Government of Canada, all in one court hearing. And that hearing was held in the fall of 1981. And the decision came down on September the 29th, 1981. And the decision was that what the Prime Minister and the federal government was doing was unconstitutional. Once again, this is not written up in the history books as much as it should be, because they try to gloss over that. But that's what happened. And that decision is there for anybody to read. If you look up the Supreme Court of Canada website for the judgments of 1981, you will find that judgment there. And it's really interesting because, as we know today, there's a lot of people questioning the judges and their objectivity. In 1981, when these judges made their decision, many of them were friends of the Prime Minister and of the government. But in those days, the judges were friends of the law first and friends of the politicians second. And we wonder today whether that's still true. But in any case, he lost and his government lost. They could not unilaterally change the Constitution. It needed a substantial number of provinces to be on side. That's what the Supreme Court of Canada decision said. So the Prime Minister, Mr. Trudeau, had to take his tail between his legs and come back to the negotiating table if he wished to have this project completed that we had begun before he left the table, patriation, a Charter of Rights and Freedoms, plus other issues that the provinces had, which like non-renewable resources, minority language rights, regional economic development and equalization, and Aboriginal rights, to name a few. And so we agreed after the Prime Minister lost in court, all of the first ministers, that we would have a 3-day final session to see whether we could get an agreement now that the Prime Minister had lost in court. And that 3-day session would be on November the 3rd and 4th and 5th of November 1981. And so we negotiated on those 3 days. Nothing happened on the first day. Everybody's positions remained more or less the same. Prime Minister never moved, even though the provinces indicated they were prepared to move in a number of directions. Prime Minister said no. And so the first day, the 3rd, went uneventful in the sense that there was no movement. Same way with the November the 4th. And on the evening and night of November the 4th, I, as Premier of Newfoundland and Labrador, with my delegation, prepared a proposal which we put to some of the provinces, Alberta, British Columbia, and Saskatchewan, at a night meeting in the Saskatchewan suite of the Chateau Laurier Hotel, and said, look, we've been watching this for the last 2 days, and we think here are some of the middle ground where we may be able to reach agreement. Do you think this has any legs? We only got 1 day to go. And if we don't get an agreement tomorrow, we go back to square one and everything remains the same, with no patriation and no charter rights and freedoms or no anything else that we had on the table. And these provinces said, you know, this looks like a pretty good proposal. We think this has legs. And so we invited more provinces of the 8 to the table, and we negotiated through that night up until about 1 o'clock in the morning, all the provinces except Quebec. And the reason why Quebec wasn't there was we couldn't find them. That night, a lot of the delegations had dispersed because they knew one big day was coming. And the Quebec delegation had all gone to Hull, Quebec, across the river to a late dinner. And so there was nobody home in their hotel rooms. But we went ahead and negotiated in any case and came up with a proposal that everybody agreed to, all the other 7 provinces agreed to. And I was charged with retyping it up because I had started the proposal in the beginning, earlier in the evening. And then after that was typed up, that I was appointed or elected to present that to all the 8 premiers the next morning at an already scheduled breakfast. And the 8 met for breakfast every morning before we went on to meet with the other governments, the federal government and Ontario and New Brunswick. So we had our own little club. And so I presented that the next morning to all, including Quebec. Quebec, of course, were back to sleep during the night and knew about the meeting. Of course, they were part of the group of 8. And so we showed it to Quebec before the meeting began. So they had an opportunity to look at it. And all the other first ministers through the night had seen parts of it and were in favor of a lot of it. And so they had a chance now to look at it, the complete document, retyped and so on. And all of them except Quebec agreed without amendment and that this should go forward as our presentation to try to break the log jam and get a deal before the 5th, that day was expired. And so I was elected again to present that to all 10 first ministers later in the day for that final meeting, which I did. And with some further amendments, it was that which became known as the Patriation Agreement, which included the Charter of Rights and the other provisions, and which the next year, when it was introduced to the House of Commons in UK and in Ottawa, became the Constitution Act of 1982. Okay, and so that's the history of it. It was first called the Patriation Agreement, and that's where the signatures are of all of the provinces who agreed. The signatures of the 9 provinces and the federal government. Quebec objected and did not support any of the procedures, and therefore remain to this day outside the Constitution in that sense. Even though today now they've used the Constitution Act from time to time, even though they're not had never signed on and haven't signed on to this day, which is a peculiar anomaly of our constitutional architecture today. Really unusual, and I don't know what's happened anywhere else in the democratic world. Now, we're interested tonight in the Charter of Rights and Freedoms primarily because it's the section of the Constitution Act which has been most affected by the pandemic, by the so-called pandemic of 2 years ago, when the governments of the world panicked over a virus and very quickly took on an aura of fear and led the people to believe that millions would be dying in the streets if they didn't do something drastic. This all got started, by the way, by a group of scholars out of the Imperial College of London, were the first to predict that this virus would be vicious, worse than the Spanish flu, and there'd be millions dying in the streets. And all the governments, including the White House in America and all throughout Western Europe, bought into this, which was a false narrative, but it was what was bought into at the time. And very early on, in the first couple of months, it became clear that this wasn't going to happen. It wasn't as the Imperial College of London had indicated. But by that time, fear had set in. The governments had established started to establish their mandates and their draconian lockdowns and so on. And then when the Imperial College of London no longer had any credibility, there was a group in the University of Washington in Seattle who took up the cudgel and once again spread fear, which the White House and then, of course, Canada followed suit, and France and UK and Germany and all the rest of the Western nations, and then most of the nations of the world. And so this whole business was predicated upon a foundation of sand, that all of what was predicted did not happen. The draconian measures were put in place when they weren't not necessary. And very early on, it was known by a lot of people in government that it was likely that the cure was going to be worse than the disease, but they didn't listen. And to this day, a lot of them still don't listen, even though the science is out there big time showing what that they'd done was draconian. But more particularly for our discussion here tonight, and for what's happened in the last 2 years, is the fact that in imposing these various measures, they violated the Constitution. They violated the Charter of Rights and Freedoms. The Charter of Rights and Freedoms has 4 major sections in writing which protect your freedoms and your rights. Section 2 of the Charter deals with your freedom as a citizen of Canada, your freedom of conscience, your freedom of religion, your freedom of expression, and your freedom of the press. And also in that Section 2, it talks about every individual in Canada has the freedom to associate and the freedom to assemble. Well, we know what's happened to that. A lot of the Christian churches in Canada know what's happened to that. And we all know what's happened to that is related to the convoy. The governments began violating that, both provincial mandates and federal mandates, began violating Section 2 of the Charter. Section 6 of the Charter talks about mobility, your right as an individual Canadian to be able to travel anywhere in Canada or leave Canada. That's Section 6 of the Charter of Rights and Freedoms. Once again, as we know, through the federal mandate and some individual provincial mandates, that section was violated and still is to this very day violated because the federal travel mandate is still in effect. And it's that travel mandate that I have taken a lawsuit out against the federal government myself through the Justice Center for Constitutional Freedoms. They're fighting my case right now in court. Now, others have joined that case, other individuals who have been affected by the travel mandate, and so has Mr. Maxime Bernier, the leader of the People's Party of Canada, who actually went to court, went to jail on our behalf in Manitoba in trying to ensure that this violation did not continue, but he was arrested. And so these are some of the people who are involved in my court case that's now before the Federal Court of Canada. A third section of the Charter which has been violated is Section 7. Section 7 says you have the right to life, liberty, and security of the person. And those are important. That's important. Life, you have the right to life, liberty, and security of the person. That's in the Constitution of our country. That's in our supreme law of our country. And the security of the person, of course, we all know what that means. Security of the person means that you have individual autonomy, okay? You have autonomy over your body. And so that any injection that is contemplated, you must agree to. You have that kind of right, as you know, as Hippocrates said many years ago, when all the doctors agreed to the Hippocratic Oath, you know, to do no harm and to recognize individual autonomy. So that's the third section of the Charter which has been violated. the fourth section of the charter which has been violated is section 15. And section 15 of the charter says every Canadian has the right of equality before the law. Everybody is equal before the law. No one is more equal than anybody else before the law. Well, we know what happened to that. You and I, if you're unvaccinated like me, could not go into certain restaurants, could not go to certain other places. And some of the churches who are trying to have their worship services were constrained from having that equality before the law. Others could go wherever they wanted, but Christians and others who are practicing their religion could not. And so there was no equality before the law. And there's not equality before the law now, because some can travel on plane and train and others can't. So in other words, there's discrimination right now and a violation of section 15. Now, this is very important because this whole business of putting the charter rights in the Constitution was meant to protect it. That's why it's there. It was meant to protect it. It wasn't a federal law. It wasn't a provincial law. It could easily be changed. It was in something permanent and national called the Constitution. Now, when the pandemic occurred, or the so-called pandemic, because there are many scholars and medical experts who are still challenging whether it really was a pandemic or not. And of course, they changed the definition to try to make it so. So that'll give you how uncertain they were about it, the governments were, and the World Health Organization changing the definition of it to try to make it apply, because they wanted their power to be exercised. Well, this is what happened. Now, the governments, when they started to levy these draconian measures and bringing these mandates and these lockdowns, tried to justify it. And they turned to the section 1 of the Charter of Rights and Freedoms to try to justify it. Now, ladies and gentlemen, they cannot justify it through using section 1. They have done a good job because they have the press on their side. The press went with them because the press got bought off early on with a $600 million allocation to all the press in Canada, especially the mainstream press, who took money from the federal government, some of $600 million over 3 years. Imagine over $500 million going to the press, which are supposed to be an independent voice to keep the governments honest. Well, they just became part of the government. And for 2 years, I was not able to get a letter or anything published in the papers anywhere in Canada, and many other people like me, because I was preaching a different alternative. And so we didn't have freedom of speech in Canada through the press, for sure, for 2 years, and still don't to a large degree. Most of the papers in Canada still don't carry a lot of my stuff. The National Post carried one letter just a few weeks ago, and Epic Times carried a number of things from me, Epic Times being the only sort of paper around that was still carrying both sides of the story. In any case, let's get to section 1. The governments of Canada tried to excuse what they were doing by using section 1. Well, I'm the only First Minister alive who was there and helped write section 1 and the rest of the charter. And the intent of section 1 at the time was for this to be used because this was a constitution. This was a permanent document, not like legislation in the House of Commons or in the legislatures. This was a permanent document, and therefore these rights and freedoms could only be violated under the most extreme circumstances. Extreme meaning like there was a peril to the state. The state was about to crumble. The country was about to crumble. It was insurrection or war or some like kind of circumstance. And so, as we know, the pandemic and the virus that they talk about, the recovery rate on that, if you get COVID, is over 99%. And the fatality rate is less than 1%. So that is not an extreme circumstance. That is not a war or insurrection. That's not a peril to the state. And so the governments and lower courts have misinterpreted section 1 by trying to say that section 1 applies. Well, I'm alive, thankfully, to say that it doesn't apply because the intent was not to use it in the circumstance in which they used it. And by the way, courts in Canada for a long time, right up to the Supreme Court of Canada, have been using intent as one of the things they look at when something comes before them for a constitutional decision. They look behind the legislation. They look behind the law to see what was intended. And anybody who's familiar with court decisions know that that's existing in many court decisions that have come down over the years. So intent is a factor that the judges have to look at. Well, in the two court decisions that we've had so far in the lower courts, they have not even entertained the idea of intent. And so they are being at fault, those lower courts. So I'm hopeful that there's still a chance that the higher courts, the courts of appeal of the provinces and the Supreme Court of Canada will see the error of the ways of these lower courts and rule the way I am suggesting. Number two, on Section 1, I go on to say that even if Section 1 did apply, and then my argument is it doesn't, but even if it did apply, it would not pass the tests that are in Section 1, because Section 1 says you can override these rights and freedoms, but you must pass 4 tests to do so. You must demonstrably justify what you're doing. You must do it with reasonable limits. You must do it within law, and you must do it within the context of a free and democratic society. Well, at least 2 of those tests have not been met, because no government in Canada has demonstrated, has demonstrably justified what they are doing. Now, demonstrably justify, I remember when we wrote this, it was just justifying, and a number of premiers wanted to make it stronger, including me, and that's why it's demonstrably justify, not just justify. And that means, in public policy terms, that you do a cost-benefit analysis and see whether what you're proposing to do has more benefits than costs. And if any government of Canada had done that when they were proposing these mandates, they would have seen quite quickly, wouldn't have taken them that long, that these measures had the potential to be very devastating. Like, for example, how many people have died in Canada because of delayed surgeries? How many people have died, right, because of injuries that later they died because they weren't seen by a doctor quick enough because their appointments were delayed? I know some myself, quite a few as a matter of fact, some very close to my family who were in that kind of circumstance. And so they didn't demonstrably justify. And if you look at all the health orders from St. John's of Victoria, there's no place in there where they've done any cost-benefit analysis to demonstrate that what they were doing could be justified. Okay, they didn't do it. And so they didn't meet that test. And they didn't meet the 4th test either, that all of these, any of these measures had to be done within a free and democratic society. And what does that mean? A free and democratic society means that you must involve the parliament of this country, because we're a parliamentary democracy. That's what free and democratic society means in Canada. We're a parliamentary democracy. But the parliaments were only open long enough to give the government and the public health officers more power, not to guide the mandates that they were looking for. No select committees of the House, for example. There should have been a select committee in all of the parliaments of Canada, which should have overseen what the government wanted to do. But no, the governments didn't want that. The governments wanted to just use or get more power and use it without keeping the parliaments open. Well, that's not a free and democratic society. So either way, Section 1 does not apply to the circumstances that we have now. And I'll be making that argument in court too, with my lawyers, and have already done so through documents that we've submitted to the court. So, ladies and gentlemen, we're into a situation now today where we have every government of Canada, the 3 territories, the 10 provinces, and the federal government having committed an act of violation of our Constitution. And that cannot be allowed to stand. We must band together to ensure that the damage and the violations that were done over the last 2 are corrected. Just because there's a few mandates now lifted, we must not forget what was done. Because if we do, and we don't persuade the courts to change the course of what the governments did, the next time round when there's an emergency of some sort, or an alleged emergency, the governments could use this as a precedent if we don't change what the governments have done. If we don't get the courts to rule in our favor, this becomes a precedent, and therefore the Charter of Rights and Freedoms becomes diluted. And we will not have a free and open society like we've had for the last 40 years. And so this is extremely important, and why I have obviously every day now argued for the last year and a half, almost 2 years, every day doing public meetings in public, and also a lot of these Zoom calls to hundreds and hundreds of people all over the country, and even in the United States. And I've actually done some meetings for people in Germany, in Europe, explaining to them what's happening in Canada. And I'll be doing another one with an international group in another week or two along the same lines. So I've gotten to know a lot of the people who are involved internationally opposing what's going on, including some of the great medical experts like Peter McCullough in the United States, the people in Canada, for example, Roger Hodgkinson, Dr. Roger Hodgkinson, Dr. Eric Payne, Dr. Brian Bridle, Dr. Paul Alexander. I know all of these people through what's happened, and they are very convincing in the science that they produce. Dr. Paul Alexander was actually an advisor to the White House, for example, got his education at McMaster University in Hamilton, Ontario, a very smart guy. He actually was an advisor to the World Health Organization as well. So these people who have the science on their side and who can persuade anybody that they're right, have been ignored by all the governments of Canada. And when they've asked for a meeting with them, the government has refused to even give them a meeting, because they know, the governments know, that these experts have science, more science on their side than does the government. Unfortunately and sadly, the government has refused to listen to these people who are respected scholars all over the world, not just in Canada or in the United States. In any case, that's my presentation. I know I went on quite long, but I hope I did it in the hope that I gave you a full and complete, what shall I say, meal as it relates to the Constitution of Canada and how it's being violated. Thank you very much.
Well, thank you. Thank you very much, Brian. That is an exhaustive commentary on what has happened in the last few years. And it's spoken from the viewpoint of one who was right there, who was involved, and at almost 80 is not content to rust out, but to burn out. And I like that in a person. That's the same way I feel. And I think the most important thing we can do now is to turn this over to Perry, who will moderate the question and answer period. So Perry, you're on.
Okay, thanks, Reed, and thank you, Brian, for that incredibly comprehensive presentation. So we're going to ask everyone to keep their mics muted, and also to submit your questions to the chat box. And what I will do is I will select questions to ask Brian. Sometimes they will be very similar, so I will combine two questions into one, so he'll be able to speak to as many people as possible. And depending on the time factor, if we wish to do so, we can go to general questions and people can directly talk to Brian, but initially we'll go to the chat box. So if you have a question, I've opened up the chat box, and you can please write your question in there and I'll transfer them over to Brian. I have one right off the bat, to be honest with you. My first question here, while people put theirs in, is that the first sections of the Charter of Rights and Freedoms mentions freedom of expression, right? To me, that means unadulterated and absolutist free speech. But I would like you to comment on that, because I think it's confusing for a lot of Canadians to see that and then be told that they don't have unadulterated free speech.
Yeah, well, that's one of the problems that the governments have caused, is to somehow, in their own lack of wisdom, decided that this doesn't apply in certain circumstances when it actually does. And if they want it not to apply, then they have to demonstrably justify that they can override it, but they have not done that. And so it's a simple answer for me. That was put in there deliberately as freedom of expression because that's the hallmark of a democracy. By the way, just today, I was supposed to speak for my first speech at a school on Vancouver Island, and it was all approved by the principal and everybody. But late last evening, the teachers who were organizing were called into the principal's office and told that what they had agreed to the day before, and that Mr. Peckford could come and speak to the students and outline the history of the charter and take questions from the students, was canceled. And so they'll just give you an idea. Freedom of expression has just gone by the wayside at a school that was attempting to allow free speech to occur. So right here on Vancouver Island, here in British Columbia, we're quite familiar with that, as well as, of course, the Times columnists in Victoria refusing to carry my letters once the pandemic began, and they saw that I was not going to follow the narrative that they were starting to follow with the government. So freedom of expression is at the centerpiece of democracy, and we don't have that today. So we do not have democracy in Canada today as we speak, because our charter rights are being violated, charter rights which are freedom of expression.
Thank you. I'm going to go to some of the questions that people are filling in now in the chat box. From Susan, Brian, what do you think about the issue coming forward right now with the WHO getting countries to sign up for international pandemic response? Canada would no doubt jump in.
Yes, that's come up a lot in the last little while. Now, like a lot of things, there's the truth, and then there's the half truth. And it's very important for us as we oppose things to make sure we're on really solid ground, as I think I am as it relates to the charter, why I'm willing to go all the way to the Supreme Court of Canada. I mean, even if I lose at the federal court, I'm going to appeal it to the Supreme Court of Canada because I believe my cause is just and I can justify what I'm saying. The same way when we deal with the World Health Organization. Now, we know the World Health Organization is a flawed organization because of the way they acted back when the pandemic began. And we're very pro-China at the time. And because, of course, some of the people on the WHO were friends with China even before they took their positions in the World Health Organization. So it's been a very flawed organization and has been right on some things, but wrong on a lot of others. But they really are trying to dominate the world health policy. And there's no question about that. So they are. Now, what's happening in the last while, remember, they're a part of the United Nations, and a lot of countries are part of the World Health Organization, including Canada. Now, what they are doing and have been doing for the last 2 years in trying to globally look at this pandemic, they have tried to exercise more and more power and information sharing and so on. And two things are happening right now is that they're trying to consolidate a situation where the next time there is a pandemic or an alleged pandemic, they'll have more say and more power over the nations who are part of the World Health Organization. And there are two things happening right now, and people are getting confused online about these. In a couple of days, by March, May 22nd to the 28th, they're having a meeting where they're trying to amend certain of their international regulations under the World Health Organization. And they're also looking to, over the next couple of years, sign a new treaty. So, but in both cases, they're trying to gain more and more power. In this first section, where they're amending existing regulations, they're not taking over the country's health system or destroying our sovereignty. The countries have the right to say no to these regulations. So where the opposition should be put in Canada is towards our government, our federal government, saying to them and saying to the MPs, we don't want you to agree to these regulation changes. And then later to say that we don't want to sign that treaty that's coming down the pipe over the next 2 or 3 years. So one is changes to regulations that are happening now, which we must oppose, and changes or a new treaty to enlarge their power and then take away power from the countries, which would come down over the next 2 or 3 years. Now, the World Council of Health, I don't know how many people have gone into that, but there's a brand new organization called the World Council of Health, made up of lawyers and doctors and scholars all over the world, including Dr. Trotsky from Canada, who's on their board. And they are opposing what the World Health Organization is trying to do, okay? And so if you go into their website, the World Health Organization, you'll see the full argument on why we should not even go along with these amended regulations, because they move towards getting more power. They move towards it. The treaty in a couple of years will finalize that deal, sort of thing. But they're already moving through existing regulations to amend it. And so the World Council of Health has got a wonderful explanation of this and a letter out to all of the leaders of the world saying why they oppose this. And I would encourage everybody to go in. So to answer the question, Canadians and people everywhere should be very concerned that the sovereignty of our nation over the next few years is in grave jeopardy. Now, to be clear, this just didn't happen. As much as I don't like the Trudeaus, I mean, I oppose Pierre Elliott Trudeau all the way, not only on the Constitution, but on other matters, as anybody could look up the record to show. I never was a fan of his, and he was never a fan of mine, of course. And so I opposed him on many things because I thought he was hurting Canada in many ways. And the same way with his son, I've opposed his government and that party ever since he became the leader of it, and even before. So I'm not on their side. But let's be clear. We began to lose or to move towards losing our sovereignty when we began signing international trade agreements. And the Conservatives were involved in this as well. So when we signed on to the Trans-Pacific Treaty a number of years ago, we were signing away and moving towards losing our sovereignty as a nation state, okay? That's when Trump came along, and whatever you think of Donald Trump, he took the United States out of that agreement, and wisely so, wisely so. Mr. Trump was right on all the big things. Mr. Trump was right on all the big things, and history will record that, and some people are seeing it now today. And so our problem started, it didn't happen with the US Free Trade Agreement, but it has happened with the Trans-Pacific Free Trade Agreement. And Trudeau and Christian Friedland and others in the government of Canada and others who were in the Conservative government have moved the country more to losing our sovereignty. And we've got to stop it. And now is a good time to start with these regulations. But the chances of Canada not going along with these amended regulations only in a few weeks, what's today, the 10th or 11th, we only got 10 or 12 or 13 days, is not great, because we all know where the Prime Minister and the government is, and we know that he has all of the NDP party in the House of Commons on his side, so he's got a majority. And he's got to deal with them that he'll have a majority until 2025. And so we're in a real conundrum right now. And so the question asked, although asked in less than a minute, is taking me 5 or 6 minutes to answer for obvious reasons.
Okay, thank you, Brian. Let's get to a couple of other quicker, perhaps, questions. Linda writes, thank you, Brian, for a wonderfully informative presentation. When do you expect your court challenges to be heard?
Okay, it's in the courts right now. The way the courts work is case management. So both sides, the government of Canada and the lawyers for me, are presenting their arguments, and then they have cross-examination all before the hearing begins. It's still a hearing, but it's not a public hearing in the same sense as the later. And so that's well underway right now. One of the things which has delayed it recently is that the federal government has increased the number of lawyers that's on the case and increased the number of their witnesses. And so there are more witnesses now to question, more witnesses whose evidence can be cross-examined. And so that takes our time frame a little more. We were hoping for the hearing, the actual hearing, to be in September. to get through all of this cross-examination over the next few months and be ready for a hearing in September that may have slipped now to October. And so we're still very hopeful that the hearing will be held this year and that the judge will render a ruling by the end of this year. So that's where we are on my court case. It's being handled by the Justice Center for Constitutional Freedoms. And the lead lawyer is one that they've hired outside of the Justice Center, a gentleman by the name of Keith Wilson, who has argued other cases before the appeal courts and is a very seasoned lawyer. And him plus 3 and 4 other lawyers from the Justice Center are pleading the case right now as we speak. And so that's where it is. Anybody who wants to contribute to the case, because it's all done, the Justice Center just takes, is not a government agency, gets no money from the government, wouldn't take it if it was offered to them. And so they just depend upon donors, individual donors across the country to keep these cases going. And of course, I had to sign an agreement that if at the end of the day, there's a difference between how much they raise for the case and what it costs to fight the case, then I have to cover that myself. That's the deal I've made with them in order to be able to get this case in the courts. So that's where it is today.
Thank you, Brian. Hal asked, what happens if the Supreme Court rules that Section 1 does apply?
If the Supreme Court of Canada at the end of the day rules that what I'm arguing is wrong and they are right, then I believe our democracy has been permanently damaged and that a new precedent has been set and the Charter of Rights and Freedoms will lose its power. And at that point in time, I believe Canadians are going to have to consider whether they want to establish a significant civil disobedience across the country to tell the powers that be, including the court, that we want massive changes to the way the country is being operated, and we don't want to lose our democracy, and therefore we're going to insist upon major changes. That's what's the likely outcome of all of this. I don't think it's going to go away. I think there's a substantial number of people like me that believe that abuse has begun on our Constitution. We're still hopeful that the Supreme Court will see the error of their ways. Imagine a judge not including everything that's in the Charter in his argument. For example, the Charter begins with, this country is founded on the supremacy of God and the rule of law. And one of the courts ruling on this pandemic never even included that in rendering their decision. That's a fatal flaw by that judge. That court has made a mistake. They don't have the right to select what they're going to use in the Charter. They have to use all parts of the Charter that are relevant. And obviously, those two parts principles are very relevant.
Thank you. Edward asks, Mr. Peckford, you spoke of the difference between federal law and national law. Could you please elucidate this?
Yes, federal law is a piece of legislation that goes before just the federal government, and therefore only applies to the federal jurisdiction. Same way in the province. Provincial legislature passes a law. It is limited in its scope. The only thing we have which is national, in other words, includes both federal and provincial and applies to everybody in Canada, is the Constitution. And that's what the Constitution stands for. It's national. Canadians, because we've become a little lazy over the years, when you hear people say the word federal, you automatically think it's national. It's not. That's a big mistake. The only thing that's national is our Constitution, the things that are in our Constitution. Everything else is either federal and just applies to federal jurisdiction or provincial and applies to provincial jurisdiction. The only thing that's truly national and covers everybody is the Constitution.
Okay, thank you so much. Josh asks, I would be curious how you, Brian, feel about the Conservative Party currently and how effective or ineffective they were during the pandemic. Will they be able to right the boat?
Okay, I'm glad you asked that. And so I must declare my position here. 2 years ago, I left the Conservative Party of Canada. I was a part of the Conservative Party of Canada, or the Progressive Conservative Party of Canada before that. All the while I was in the Parliament or in the legislature of Newfoundland. So it goes back to 1972. So from 1972 to 2 years ago, I was a member of the Conservative Party of Canada or the Progressive Conservative Party of Canada. I had to leave it 2 years ago because I couldn't take it anymore. They wouldn't answer any of my letters that I wrote them, the leaders of the party or the MPs or whatever. And so I became very disillusioned. They were not willing to stand up to the government of Canada the way I thought they should. They didn't articulate their positions very clearly. And so I ended up leaving the party and I joined the People's Party of Canada. And I'm a paid up member of the People's Party of Canada today. Now I have a blog called Peckford 42, Peckford number 2.wordpress.com. And you can see my writings in there. I write there every day. Even no matter how busy I am, I'll get a few moments to write something on there. And there are many essays on there explaining my position. But I'm still, the People's Party of Canada are not in the Parliament of Canada right now. There's no members elected. And so I have to comment upon who is in the Parliament of Canada. And I'm very sad to say that if I thought there was any hope of the Conservative Party of Canada, because they're such a large party and have such a history, one would be tempted to join them. But I don't see any light at the end of the tunnel. What's happening now in the leadership is that the cover of the book is being changed, not the book itself. For example, the Conservative Party of Canada, the Liberal Party of Canada, the NDP Party of Canada, and the Green Party of Canada do not carry their financial statements on their own website. So how can you trust a party that you don't even know where your money is going, if you're a member of that party, to handle the finances of the country as a government? And I have written about this just recently again. And so I don't have any qualms about saying that I cannot find anything worthwhile that will give me any hope that the present parties, unless they completely reform and became more honest and transparent and accountable, and don't change. And the other thing that as the question asked, what did they do during the pandemic? It was only near the end when the truckers came on the scene that some Conservative MPs started to speak up. But very early on, when they knew better, when a lot of their members were calling them and saying, why are you going along with the Liberal Party? That they start to get some courage to speak up. So the Conservative Party of Canada has been a very big disappointment and remains that way today to me.
Thanks, Brian. I'm just looking at the time right now and asking, there's still several questions here. Do you want to continue answering them? Because we had our original timeline of, you okay with that?
I'll go for another 10 minutes.
Okay, all right. Let me just look quickly here and see who I can include on this. Really quickly, I think you may have answered this in part. What is the timeline for your lawsuit proceeding? This is from Reed. What is the timeline for your lawsuit proceeding to the courts? Can the government delay this so its impact is minimized?
Not anymore. Now that it's in court, it's up to the judges. So it has moved along, and we don't sense anything there, except that they brought in more witnesses and more lawyers. So it has delayed it a little bit. But we hope to have a decision by the end of the year. Of course, that's not the end of it. Whoever loses in that court in this first go round is going to appeal it to the Supreme Court of Canada. So we've got another year beyond the end of this year to go before we get a final decision.
Yeah. Okay. Thank you so much. Some of these are not questions as such. They're just thanking you for your wonderful exposition on things like John Diefenbaker's Bill of Rights. I'll just sift through a few of these. From Stuart and Janet's, their iPad anyway. Are the vaccination requirements for federal or provincial employment related to violation of the security of the individual? Can employees be fired legally for not receiving a medical procedure?
I don't think they can, but they are being done so. By the way, I've had some luck in the people who've written me who are employees of a municipal council and sometimes in a university where I've written a letter just saying, as the last First Minister alive who helped craft the Charter of Rights and Freedoms, if you let this person go who's been employed with you, and you're breaking really their employment contract, you're violating their rights under the charter to employment. And you would be also, if you're coercing them to get a jab, if you're to get an injection, you're violating their rights of security of the person. So, but most employers are still going along with the government and ignoring what me or anybody else is saying. I had a lady today call me from Saskatchewan, who she lost her job yesterday morning when she went to work for Parks Canada, when they said, I'm sorry, but you still haven't got your vaccination and your job is no longer here. So that'll just give you an idea of what's going on still in the country as we speak, just this morning. So this is why people like me are speaking out so loudly and are ready to go to court, because I am firmly convinced that these are violations of the charter, where people's jobs are taken away from them because they haven't been vaccinated, and the same way with the travel mandate and so on. And I firmly believe there's a day of reckoning coming when these governments are going to be held accountable for the actions that they took, which are clearly unconstitutional.
Okay, so two quick questions. One person writes, what would Jeremy, he had a longer question, but he's paraphrased it here or shrunk it. What would a new leader need to do to win you back to the Conservative Party of Canada? What kind of position would such a leader have to take for you to say, okay, I'm leaving and going back?
Okay, they would have, first of all, to show me where they spent the money. Remember, it was Andrew Scheer, leader of the party, not too long ago, and he's still in the PC caucus, who took some of our money when I was a member of the Conservative Party and used it to finance these kids in private school. He's never been held accountable by that for the party. He was a shadow minister when under O'Toole, and no doubt will be one now when whoever the new leader is gets elected. So that's not accountability.
So you're talking about corruption.
Exactly. They need to clean up their own act, right? And number two, publish their financial statements, get them audited by an outside auditor, and publish them on their website, like the PPC is doing, for example, the only one that's doing it. Number three, they've got to reform their policies, right? They've got to reform the policies. The first one being this would be very important. I want to see a leadership candidate tell me that they oppose what the World Health Organization is doing, that they will not stay in the World Health Organization if they become Prime Minister of Canada. And I want to, and fourthly, just to give you four things, to make it briefly, I want the party to make a firm policy position that they will establish an inquiry and try to get all the provinces on side to form a national inquiry to review what happened in the last 2 years, to see where the law was broken and to make people accountable and to go all the way to court with it, and to see where they were unconstitutional and to challenge and find out where they went wrong on the science. And that would have to be an independent, a completely independent inquiry from government, not a royal commission, an independent inquiry where the government would go out and ask for advice from other citizens and other organizations in Canada, not just within the government, then establish it independently and allow it to do its work and hire whatever experts it wanted to hire, and to call to the bar, if you will, any person who was in any way involved in any of the mandates in any part of Canada. Now, if they did those four things, then I might have to reconsider.
Okay, all right. And then the last thing I just mentioned, because I did say two things, was a melange, a mixture of things I've seen here about civil disobedience and what exactly you meant by that. And then also, is the time appropriate for that now, or would that be something that would be indulged in a future time?
I think we should start it now. I think what's happened on the legislature of Victoria, for example, is a great example of civil disobedience. Remember, we're allowed to assemble, we're allowed to associate. This is civil disobedience is so much a part of every single democracy, going all the way back to Greek times, going back to Solon's time, going back to Socrates' time. Who was one of the great civil disobedient people of the world? Socrates, Cicero, for example. That's even before the time of Christ. So yes, civil disobedience is very much a part of the fabric of a democracy. And it's already happening now. on the steps of the legislature of Victoria, and we have to continue that. We must continue. We must never stop that until we see the changes that are necessary, that our charter is restored to where it ought to be.
Thank you so much. So I think we're going to end the Q&A session now, okay? Because we've hit on all the major issues, right? One new message has come in, but I think at this particular time, in consideration of what we've been doing, it might be time to start wrapping things up. One thing this one gentleman at the end here just wants to say, it's not really a question. He says, please inform Mr. Peckford that, this is Julian Lazinski, please inform Mr. Peckford that as a physician, if I was to support his views openly in public, then I will be sanctioned and disciplined by the colleges of the provinces that I'm registered in. So I think that's what a lot of people have been feeling. You know, I'd like to say this, but now I'm terrified of saying it. You know.
Yes. Well, Charles Hoff is a good example. Dr. Charles Hoff up in Lytton, right here in BC. He's been chastised by the College of Physicians and Surgeons, and he lost his hospital privileges. And he's trying to challenge that now, the college, and what they've done to him. They've almost destroyed him completely. So there's a really good example. And there are other examples in Ontario where the Ontario colleges come down on Dr. Patrick Phillips and others. Yeah. And so that's why I don't say it lightly when I say, you know, that our democracy, we don't have democracy anymore. We've got to restore it. And I also say it in the context of this, which I think you people will understand. And it's this: I wasn't born a Canadian. I was born before Confederation. I was 7 years old before Canada joined, Newfoundland joined Canada, 1949. I was born in 1942. But I, like my father, and like everybody after me, became Canadians by vote, right? Not by coercion, but by a referendum. And so I have adopted Canada. And so I'm somewhat like the reformed smoker now. I'm more against smoking than any of the people who never smoked in their lives before. So I'm more of a Canadian. I've adopted Canada, and I've tried to make Canada work, and I'm still trying today. So it's very sad to see, and I want to stay alive long enough to see that charter restored.
Well, thank you very much, Brian. Your talk, in some ways, paints a very grave picture of our democracy. And in many ways, I feel that those of us who have lived long enough and have seen things happen in this country, I don't think we've ever known a time when our democracy is in such peril.
Never.
But at the same time, I want to thank you because you provide hope. You provide some hope. And that's what our organization tries to do. It tries to provide some hope for Canadians that there is an answer to this huge problem in our country. So thank you so much. We really appreciate it. And you're going to have a lot of support coming from Freedom Defense Canada. Now, just for the rest of you, you need to know that what we are trying to do is to continue to provide good speakers for you. And yes, Lindsay Shepherd, who was on the faculty of Wilfrid Laurier University in Waterloo, she ran afoul of the powers that be at the university, and her freedom of speech was greatly curtailed. She has written a great book. It's called Diversity and Inclusion, and she's got exclusion. She is going to be our next Zoom speaker. And I think I'm right. Correct me if I'm wrong, Perry, but I think it's on July 6th. Is that right?
July 13th, I believe.
Oh, July 13th. Okay. So July 13th, you're going to hear more about this, and it'll be another great Zoom experience for us all, educating us from a very youthful point of view, from someone who has experienced the tyranny of the powers that be on the freedom of speech in our country. So we invite you to stay tuned for that when it comes in July.
And we will
So-
keep you informed. I'm sorry, Reed. So
Yes,
we'll keep you informed
absolutely.
about all the details of that when it comes up. And you'll have a
So
chance.
on that note, a future note for our members, I'd like to thank all of you for coming to the Zoom meeting tonight. And I know that you go away having been greatly illuminated by a very selfless Canadian who, almost 80, still is fighting for this country. Thank you again, Brian, and God bless you. Thank you all.
Wonderful to see you again, Reed.
It is. We'll see each other again.
Thank you very much, Brian.